Greetings, everyone. This is Star coming back to you from some more life training exercises with another TISC episode. Thought you should know. The topic of this lesson is going to be Trademark 101. But before we get started, let's go over a lawful disclaimer. This is not legal or financial advice, but public knowledge that we were too lazy to find out by not reading and studying. Doesn't help that we didn't know what we didn't know. But now that we know better, we do better. This is for informational, educational, and geek entertainment purposes only. Remember to do your own research, trust your own discernment, and take personal responsibility and liability for your own actions or lack thereof. Now, back to pleasure. What is a trademark? Well, it is a mark which can be a word, phrase, or slogan or logo that is used to distinguish you, your products or services from others in the world of trade or the sea of commerce. And just in case you're wondering, for those of you on the private journey, your franchise name is your trademark. However, you don't own it because you didn't create the public entity and you never claimed it, nor made it known by registering it in the public. Remember, you always have to give notice. Now, you are the specific source of that name, but nobody knows it or want to acknowledge it. So your name gets tossed around and raped like a global $2 hoe. In other words, the estate of that name and what's created because of it is used by all types of entities to tap into your energy, your currency, and you are completely unaware. So, how do you stop being pillaged and plundered? Well, you brand yourself. You are a whole experience by yourself. This doesn't even include your talents, your gifts, your artistry, nor your obtained experience and knowledge. Protect your brand by marking your trade and registering it with the appropriate public notice agencies. This ensures that the globe knows that it's authentically you transacting, instilling consistency and quality. It also provides you legal protection from others using, copying, and forging your mark without your permission. And this includes securities investing. Now, when and how you give them permission is a whole other lesson because in the past we have done so ignorantly, lazily, and unfortunately, blindly. But once we know better, we're going to do better. Now, here are some basic steps for protecting your intellectual property. First, you want to create the mark. Then you want to register the mark or give public notice. Then use the mark in trade, commerce, or business. Watch out for infringements, and then protect your property. Now, step 1, creating your mark. Speaking of your appellation, it was already created by your mother and father, but you make it uniquely yours in whatever way you creatively want to, or any other intellectual property you wish to protect. Remember, it can be a word, a phrase, slogan, logo, etc. that is unique to you and your business. Next, you'll want to register your trademark to make it legitimately noticed in the public. In North America, you can use the USPTO, which is the United States Patent and Trademark Office. If you are a true child of the world, then you may use systems that range across several countries like the Madrid Protocol, also known as the World Intellectual Property Organization or WIPO. You also have the European Union Trademark, EUTM. You also have ARIPO, which is the African Regional Intellectual Property Organization, which covers English-speaking African nations, and the OAPI, which is the Organisation Africaine de la Propriété Intellectuelle. Now, forgive me for my French-speaking natives if I mispronounced that, but this covers the French-speaking African nations. And in Southeast Asia, there is the Asian TM view. Now, after you have registered your mark, you must use it regularly. Funny thing is, if it's your name, you've been known to use that name and have been using it in the public since it was granted to you. But to maintain its validity for trademark protection purpose is keep using it in commerce. In other words, keep transacting, operating in the public with that mark. You cannot trademark a word or phrase and then keep it private and never use it. Why? Well, its use in commerce is essential to the purpose of protecting it federally. If you fail to prove use of it in commerce before the application in America, then your application can be rejected. And if you don't maintain its use after registration, in many countries, it can be canceled for non-use. Now, you may apply for a trademark under an intent to use, but eventually you'll have to prove its use under what the USPTO calls a statement of use within a set time frame. Now, what is that time frame? Well, it's within 6 months of the notice of allowance issued by the USPTO. You may request 6-month extensions, but best believe you're going to pay for each extension. And the total amount of extensions is limited to 36 months or 3 years. So please be intentional. Now, once you are registered, make your ownership clear to deter possible future infringements. Trademark versus the registered mark. Now, you can add a TM for unregistered trademarks or registered mark for those that have been successfully registered. What's the difference? Well, it's simply the legal protection and registration. The TM symbol is used to signify a claim to a trademark, even if the trademark is not officially registered with a government authority. Anyone can use TM without formal registration to indicate they are using a name, logo, slogan, or design as a trademark. It applies to both common law, i.e., unregistered trademarks, and trademarks in the process of registration. It simply provides notice to others that you claim the mark as your trademark. And in America, you gain limited rights to actual use in commerce under common law. However, these rights are geographically restricted and harder to enforce compared to registered marks. And what I mean by geographically restricted, that means it's restricted to the state of use. So if you have a business that's only operating in one state and you're using that TM symbol, it's only protected in that state under state laws and their common law usage. However, if you're using it in another state and is not properly registered, you have to fight infringements in each state individually. Now, on to registered marks. The R symbol indicates that the trademark is officially registered with the relevant trademark authority. You can use this after you have properly registered your mark. Now, using that R symbol without a registered trademark can result in legal penalties for false representation for you. So ensure that you are in fact registered successfully or you'll be paying the consequences. With a complete registration, you are now fully covered nationally and have presumptive validity in court, which means you get to use fun words like injunction, damages, and statutory penalties for infringers. Again, just to go over some benefits and differences between unregistered trademark and registered, just take a look at the screen. You guys can read. All right, now, once you reviewed that, we're going to go on to some helpful tips and tricks. So if you're using Microsoft Word, to input the registered mark symbol, you would use Control plus Alt plus the letter R. And I had to try it myself to make sure it still works because things change. And to input the trademark symbol, meaning the TM, you hit Control plus Alt plus the letter T. Now, the other easy way to do it in any program that allows you to draft documents is to just insert special characters in Google Docs or symbol in Word. Now, after all this is said and done, all you have to do is watch out for infringements. Watch for others using similar marks that could confuse your customers. And yes, businesses and establishments are your customers just as much as you are theirs. Trade and commerce is a two-way street. But if you do not have a contract or agreement with an establishment, corporation, agency, or other entity, and they are using your mark without a license, express permission, or contract, then it is infringement. We'll get into how to further protect your mark, but now a little something for my history buffs. What's the origin? Referencing trade history, family crest and coats of arms can be considered historical precursors to modern trademarks. They serve the same purposes of identifying the source, ownership, or affiliation of goods, services, or individuals. Coats of arms were used to identify individuals, families, or organizations, especially in medieval Europe. They were unique symbols that distinguished one noble family or entity from another, much like trademarks distinguishes businesses today. Over time, these symbols became associated with the reputation and quality of the family or organization they represented as well. They also signify the origin of the goods, especially in international trade. Now, in addition to personal and familiar use, coats of arms were sometimes used for commercial purposes like craft guilds and merchants. Guilds and tradespeople used symbols inspired by heraldry to mark their goods, ensuring customers knew the source of high quality products. These marks functioned as early trademarks, helping to combat counterfeiting and maintain brand reputation. This marking is still widely used today and can easily be seen in leatherworking and woodworking crafts. Now, trademarks can be licensed or assigned to another person. However, coats of arms were typically tied to a specific family or individual and could not be sold or licensed for commercial use. Presently, family crests and coats of arms are not typically considered trademarks in modern legal terms because they aren't used commercially. But on the contrary, if a family crest is used in commerce, i.e., as a part of a business logo or product branding, then it could potentially be registered as a trademark provided it meets the criteria of distinctiveness and use in commerce, keeping with the tradition of showing origin and originality. Now, if if your family is known for a particular skill or trade, I think you might want to consider a family crest and a family business and get it registered. Just a consideration. Now, back to protecting business. Back then, the College of Arms in England or the Court of Chivalry were the authorities that aided in preventing misuse, counterfeits, or duplications. What say ye today? Off with his head! Hand, sorry. Now, seriously, if your trademark is infringed, you want to gather the evidence and give notice via a cease and desist notice with, of course, your proof. The letter should politely but firmly ask them to stop using your trademark. And depending on the corporation, you may come to a negotiation outside of court, which can include a settlement or brief license for use. But I suggest negotiating getting compensation for that license, i.e., permission, if it's for commercial trade purposes. Now, please don't rake in dough on my account and not share the cake. How greedy of thee. Now, should you not be able to come to an agreement, then a dispute exists which can be administered in the appropriate courts. Thus, you'll need to take legal action by filing a complaint in the appropriate court for those fun words like injunction and monetary damages. Now, federal and state will depend on whether your trademark is registered or not registered. The appropriate courts in the United States are the federal courts, which have national subject matter jurisdiction under the Lanham Act if your trademark is registered. If it's not registered, then the state courts have common law jurisdiction, which cover common law trademarks within the specific state that the infringement occurred. If this is an international obfuscation, then you're going to file in the country where your trademark is registered and also where the infringement occurred or is occurring. Should it be in multiple countries, then you may need to file in the court of each country where the infringement happened. Trademark rights are territorial, meaning protection applies only within the jurisdiction where the trademark is registered. In a nutshell, to enforce your legal rights to your work, once an infringement is discovered, document when, how, and most importantly, where. Send a notice to cease and desist. Should they not honor your notice, determine if you need to go to state or federal based on where you registered your trademark and where the infringement occurred, and file a claim for remedy. As this is typically unfamiliar territory for noobs and privates, should you need counsel, seek a trademark lawyer for filing and pursuing your case, or someone with experience in this field. I can't express enough. Read, read, read to know or familiarize yourself with your actions in commerce. Now, per Google, the Lanham Act is a federal law that governs trademarks, service marks, and unfair competition, like monopolies, in the United States. It was enacted by Congress in 1946 and is the primary statute that governs trademark law in the country. Excuse me. Now, as you can see, it helps to establish a national system for trademark registration. It protects your marks from similar marks that could confuse your customers. It also prevents from unfair competition, false advertising, dilution, infringement, property rights use. It grants civil liability for infringements, cyber squatting, and false advertising. So it's pretty much a coverall to protect the individual's rights when it comes to your services, your name, your slogan, your brand, your business. Now, in another episode, we are going to address endorsements because we've just been given blank endorsements left and right, meaning giving gifts to these organizations, businesses, financial institutions for them to utilize our credit. We're going to stop doing that mess. But for practical application, let's just say the name Jane Smith is trademarked for use in trade and commerce. To protect that name, the owner would endorse an instrument as such. By Jane Smith for, quote, Jane Smith registered trademark, and then you insert the date. Again, just thought you should know. This is another TISC episode brought to you by Star at lajalearning. Please remember to like and subscribe for more. And if this information was helpful to you, please share. If you have any questions or would like trademark services, please email your request to lajalearning@gmail.com. Thank you again. And if this was of value to you and you want to show your appreciation, send me a love offering to the below locations: Cash App at Najim Asante or Venmo at Najim L. Again, thank you for participating in another TISC episode. Take care now. Bye-bye then.